Good morning. Today is November 21st, 2024, and welcome to the New Possibilities Hour, part of the Will Work for Food project founded by Natalie Armstrong Motan. Every Thursday, Jean Lawler and I are delighted to host another cutting-edge webinar for mediators, arbitrators, lawyers, and everyone who negotiates. As you know, there's no charge for these great webinars. Rather, we ask you to contribute to a food bank if you like what you see. And since we began the series in 2020, our audiences have been so very generous, contributing in honor of our great speakers. One of my favorite parts of the webinar each week is when we announce the running total of just how much our audiences have contributed. Jean Lawler, would you please do the honors?
Always a pleasure, Jeff. Good morning, everyone. So our running total as of today is $638,123.45. I think that's a magic number. 1, 2, 3, 4, 5 there at the end. Congratulations, everyone, and keep it coming. Thank you.
That's beautiful. Thank you so much. And today we have another great presentation talking about mediation from the insurance carrier side of the aisle in insurance cases. We're going to be talking about mediating in the face of a Stowers demand. We're going to hear all about that, learn all about that from Jamie Cooper. Now, Chris Martin was supposed to be with us today. Chris had a family emergency, and our hopes and prayers, wishes and prayers are with Chris and his family at a challenging time. And we're so happy that Chris's law partner, Jamie Cooper, from the law firm of Martin, Disiere, Jefferson, and Wisdom in Texas, is able to join us today to have this discussion with us and make the presentation. Jamie Cooper is an unwavering advocate dedicated to securing optimal outcomes for insurers in high-stakes coverage disputes. Her in-house executive experience at a top national insurer provided her with unique insights into claims. Jamie has tried complex insurance cases across the country, cultivating the judgment that comes only from extensive national litigation experience. Jamie is board certified in insurance law by the Texas Board of Legal Specialization. Jamie Cooper, please tell us a little bit about the food bank to which you would like people to contribute, if they're in a position to do so. And then on with the presentation. The floor is yours.
Thank you so much, Jeff, for allowing that last minute substitution. I see lots of friends on here that we know, and hello to them. Know that Chris would dearly have loved to be here, but it's just really not possible with what he's dealing with. So thank you to everyone for your patience and your grace with what he's having to deal with right now. The food bank that Chris, though, and the firm and I support is Star of Hope Mission. It's a faith-based outreach in Houston, Texas. They serve about 1,000 men, women, and children who are homeless in the Houston community every day. So we're super excited to support them and be able to share with your audience the great work that they're doing and the opportunity, if you so choose, to support their work. Thank you. So mediating strategies when we're talking about policy limits demands. In Texas, it has this great name. It's called Stowers. And it's a really old case. It's more than 100 years old now, where Mamie Boucham was, tootling along downtown Houston in her, turn of the century vehicle. And she struck a truck, a moving van of the Stowers Furniture Company. And if you're in downtown Houston and you want to do some legal history, the Stowers Furniture Building is still there. You can still go find it. And we're talking, a monster insurance policy for that time. It was about $2,500 that the Stowers Furniture Company had to pay, for this accident. And they declined the settlement demand. They claimed that Miss Mamie was not hurt that badly. So the case goes to trial. They get a whole bunch more money than $2,500. And now this insurance company that rejected the $2,500 sure wanted that deal back. And Texas created what we now call the Stowers Doctrine, which is if an insurance carrier has an opportunity to settle, liability is clear, the settlement's reasonable, the carrier is now responsible for it. It's pretty much the same in every jurisdiction. Let me bring up a PowerPoint. Chris did have a PowerPoint ready to go for today. Let me make sure I'm putting up the right screen. Okay, y'all don't want to see me? Okay, there we go. Is that coming through? All right.
Yes,
It's not.
we can see it just fine.
Okay. And also I've got my chat open. So if, and I think the chat is open for questions as we go through. Most jurisdictions are going to have something that looks like what Texas has. A couple of jurisdictions, Florida, I'm looking at you, may have a little different rule because their law developed a little different. But in most jurisdictions, if the insurer can be liable for an excess judgment if they unreasonably refuse to settle a claim within the policy limits when liability is clear and the settlement demand is reasonable. My mediators on here know how hard this can be when we're trying to mediate one of these cases. And the claimant side is 100% dug in that they have a good demand and the carrier should have taken it and the carrier has blown it. And the carrier is dug in, no, we didn't. You just cannot find two more entrenched parties when that happens. So what are the elements in most states? In most states, we're going to look at coverage. Is the claim covered? Is the liability clear? Or do we have some sort of proportional responsibility that we're going to fight about? Was the demand actually within the policy limits? And was it reasonable such that a reasonable carrier would accept it? And did they offer an unconditional, full, final, total release in exchange? When we do these mediations, as y'all know, we'll have, we'll have counsel there on the liability side, right? If you're in California, CUMIS or wherever you are, you're going to have that separate defense counsel there. And then a lot of times you'll have counsel brought in just on the coverage, just to speak to the policy limits demand and the carrier's position on the policy limits demand. And that's where Chris and I come in more often than not. We're coming in fully to explain why the carrier did not bring the checkbook or did not bring the whole checkbook. And really, really good plaintiffs lawyers will do the same thing. And I will have a really, really good policy holder coverage person on the other side. And we have almost a separate conversation. We do have a separate conversation than the liability guys are having. They're a lot of fun and there are a lot of moving parts. And I really appreciate our mediators and arbitrators who deal with these cases because they can be a lot of fun. And I will say, these are the first ones I've gone back in person for. We're still doing a lot of mediations via Zoom. Thank you, Zoom. Thank you to all of you for doing those. But these were the first ones I was asked to go back on where we had policy limits at stake. And that seems to be the trend because the feeling is we need to have those people there. So a note to claimants. So Chris and I have done a lot of these. I've been with the firm since 2003, except for that little 3-year stint I spent in-house. We've done a ton of these in that time. Our thoughts on this to claimants, and maybe claimants, maybe carriers. We see the least success when we go before the excess verdict actually comes in. That sort of seems counterintuitive, right? Because there's always this push to go to mediation before you get the verdict. These are different though, because you have so many things that can derail a successful mediation because we don't have the verdict yet. We don't know what the jury's going to do, right? Everybody's gone. They've gotten their jury consultants. Maybe you've done a mock panel. Maybe we have some ideas of what a jury might do for it. But we have so many other questions on liability, on causation, on the coverage. There are just so many opportunities there to be crossways and not be able to make real progress, that it can be very hard before you get that judgment to find some common ground. It doesn't mean it can't be done, but I will say in our experience, it's super hard to do. When they have been successful, when I have seen them be successful, when Chris has seen them be successful, there's usually not a question of damages. We're dealing with decedents. There's not a question of liability. We know 100% how this accident, how the tragedy occurred. So somewhere we're clearing up some of those hurdles to where we're focused on just one or two issues, and one or two issues we can get past. But if we've got all of them, it makes it super hard to make progress. Post excess verdict. So we've got our verdict. We know, because we have the rejected demand and we have the carrier's position. We know that okay, now we're going to mediate. The appellate court's going to order us to mediation. The parties are going to agree to mediation. Something's going to happen. A lot of those hurdles have been taken down, because now we know 100% what a jury thinks the case is worth. We know 100% what how a jury proportioned the liability. All of those questions have been taken out of the mix, which makes it a whole lot easier. But it does make it more challenging, because now we got to do some more work, and we're maybe doing work that you haven't seen before, because up until now in most jurisdictions, the only thing you've been looking at is liability. Certainly the claimants aren't getting the carrier's file in most jurisdictions. They're not in Texas. Now, for the first time, we're really talking about, why did the carrier do what they did when they did it? And was it reasonable based on what they knew? So now the lens, if you will, of what we've got to analyze changes. Successful claimant strategies, where we've seen claimants do a really good job. We think you probably are going to see two experts on a post-excess verdict case, mediation, demand. We're going to see the trial expert, who's going to talk about the liability, who's going to talk about what the jury did, who's going to talk about everything that went into the attorney's work, the plaintiff's attorney, getting that matter ready for trial and why it had to be tried. Then we're going to see the insurance expert. Then you're going to see the coverage, and it's not necessarily a coverage guy. It's really a claims handling woman, man. It's really a claims handling person who can set up the standard of care. What would a reasonably prudent carrier have done under the same or similar circumstances? It's exactly the same tort standard that we're all used to seeing in every other case. Jefferson, thank you so much for sharing the food bank link in the chat. All right. So remember the elements. Let's recap that super quick and how those fit in, right? Our trial expert is going to talk about the liability, and they're also going to talk about the release. They're going to talk about, what did the plaintiff offer the carrier that was such a great deal, right? Deal or no deal? Why should we have taken the deal? That person's going to set that up and talk about those elements when we're thinking about it in terms of the elements that we got to prove. And then the insurance expert coverage, and then what the carrier should have done. And that's how it tracks back to meeting that burden on the claim itself for the claimant, right? Claimant's burden to prove that the carrier should have accepted this thing. Successful carrier strategies. I'm going to put these up. Appeal the tort case. It isn't an excess verdict with risks until the final appellate ruling. And that builds in a timetable for us. It gives us a moment, not the 30 days until the judgment becomes final. It gives us a moment to evaluate. It gives us a moment to come in and do some work. If we're reversed and remanded and it has to be tried and potentially reappealed, right? Lots of stuff can happen in that process. The number one hurdle we see for carriers in this, especially when their coverage at stake, is the bond. Because we're talking about potentially bonding a judgment that isn't covered. And it's excess to our policy. So what are we going to bond? Are we bonding our policy limits? Are we bonding our excess? Number one hurdle that we deal with carriers in this situation is how we do that and how we put those pieces together. Really smart claimants attorneys on the other side, they're not worried about my bond. They're not worried about my measly $1 million or measly $2 million. They want the whole darn thing. And they're going to do a turnover order. They're going to reach an agreement not to execute on it because the insured, they don't have the 80 million or 100 million. I mean, in today's tort world, we talk about some really big judgments that most small businesses, most defendants are not going to have the ability to meet. And so those claimants counsel, those plaintiffs counsel, they could care less about my bond because they want the whole kit and caboodle at the end of the day. So there are some practicalities in there that we deal with that don't necessarily spell out in the law. But if you're mediating one of these things, I think that's something that you want to know. How much skin does the carrier already have in the game? Are we already in for the bond amount? Or is there a deal where the plaintiff's attorney hasn't made us bonded at all? I think that's something you want to know. Because it certainly tells you more about how they feel about their position, in my opinion. All right. Current defense counsel is going to be our carrier's best witness. They are going to be the one to talk about the liability evaluation. They're going to be the one to talk about the reports that were going back. Your current defense counsel becomes a fact witness to the excess judgment case. And it's not because they did anything wrong. That's not what that means. It means they have got to be the one to explain the legal strategy, and they have got to be the person to explain why the carrier's evaluation that was based on the reports coming back from defense counsel were not unreasonable. And they're going to help counter the plaintiff's experts. They are going to be your trial experts. You're already going to have some sort of insurance expert involved, and you're going to have your appellate counsel that's also going to be helping us tee these things up. So there are a lot of players. This thing gets very complex, and you get a lot of moving parts. We've been involved in it in a lot of different places. We have a very active trial group. We've seen partners be the trial witness. We have a very active bad faith and coverage group. We've been your counsel, be counsel in the excess case. Very active expert witness group. Chris has been the expert witness on the standard here. And we have a very active appellate group. So we've sort of seen this from all phases and seen how the different parts can play together and how the different parts can assist in getting this pulled through. I think for the mediator, when we're trying to mediate these things, the carrier is getting input from a lot of different lawyers with a lot of different lenses on this thing. And of course, defense counsel wants to win, right? Because defense counsel told us to try the case, right? Of course, it should never have been an overjudgment verdict. How does the dynamic change if defense counsel is in-house counsel versus outside counsel? Oh, great question. Remember, the Texas Supreme Court looked at this, it's been a minute, pre-COVID, there's an opinion out there where they said there's essentially no difference between in-house counsel, outside counsel, all the same privileges still apply. They're counsel just like any other counsel. The difference is we would want to counter thinking as your counsel that's going to put them on the stand. I've got to counter that jury impression that they're on the carrier payroll, right? That they're already biased in some way because they work for the carrier, they're in-house, they were never in it to settle a case for the insured. They were always in it to protect the carrier. So if anything, great question, their testimony becomes even more important. And we're probably going to do some more work in that testimony to explain their relationship and explain that, yes, okay, I'm in-house counsel or I'm staff counsel or, big insurance company signs my paycheck. My duty of loyalty, all of my legal obligations go to the insured. We're probably going to spend more time on that than we would outside counsel, just to make sure the jury's there with us. Great question, though. The privileges and all will still be the same. They're still our number one witness. They still got to go. So thinking about kind of moving on from the roles and the players, big issues in most of these pre-appellate mediation are the towers. In Texas, one of the very first things I talked about was it's got to be a settlement demand within policy limits. In Texas, you cannot stack the towers. Meaning, it doesn't matter if my $1 million is backed by 10 million. You cannot make an $11 million demand and trigger all of it. That is the law right now in Texas. I know it's not that way in other jurisdictions. I know that there are other places where you can get pressure up the tower. But very, very hard to do because most umbrellas are going to require some sort of response, some sort of position from the underlying, right? The underlying's got to tender, the underlying's got to exhaust, something's got to happen to trigger up the tower. And that's where a lot of plaintiffs' counsel, and I think that's the other reason that can come into play why they don't care about my measly $1 million bond, because they're not worried about me. They're worried about the $80 million of the tower that they want from London or Bermuda or whoever's hanging on to it. But if you're mediating one of these, very, very possible that those folks are going to show up to our mediation, right? Those folks are going to be there on this excess verdict, post-verdict mediation, because it's their money that's really at stake. And it's their money that they're trying to get into. And how many of these layers are going to fold? How many are preparing to fold before we ever get to the mediation? That's the number one thing that I'm always trying to figure out, right? Who's in the boat with me and who's bringing anything, and how far up the tower are we really going to get? And does everybody above me in the tower have notice, right? That is the number one thing that we're often doing, is making sure when this thing went in as a claim 7-8 years ago, that the notice got transmitted up the tower, that the claim even exists. And that's if you have a tower, right? We deal with situations where there's just not enough there. And we have these happening all over, right? We can, one we've got right now here in, that maybe it's personal to me because I sit in San Antonio. We had a school shooting in Bandera. We had, a classroom full of students who were murdered. That case is in litigation. And this is a school district that has, normal, regular, in a county that has just sort of normal, regular insurance. They're not an oil and gas producer. They're not a major transportation carrier. They have what a school district or a county government would expect to need. There's no way they have enough. There's no tower there for anybody to hit. So we run into these situations that just become nearly impossible to deal with, where you don't have enough limits to cover what the liability is, or you're trying to figure out how do you get all the limits that are interested in play. And all of that contributes to what's going on at these mediations and what we're dealing with when we get there. The other thing that can happen when we're dealing with plaintiff's counsel or claimant's counsel who doesn't get coverage counsel involved, we can have some real communication disconnects. Because plaintiff's counsel who tried the underlying lawsuit has done a fantastic job, right? No question. We're in this situation because they identified a case, took it to trial, got a verdict, did a fantastic job. They probably have no eye or very little appreciation for what the coverage impediments are now and what that post-verdict excess judgment case really looks like. I cannot tell you the number of times we get into mediation and the message back to me as coverage counsel, or as, the now post-excess verdict carrier counsel, the plaintiff's counsel is not speaking the same language you are. He's got a $40 million verdict and he's not really interested in anything less than $40 million. Okay, I get you. Can we do some educating? Can we have a conversation? What can we do to help him understand, her understand, we've got some hurdles here. Number one thing that derails us, I would say, when they haven't gotten their own coverage counsel or their own excess verdict counsel involved. So picking the right mediator. y'all know I got a room full. All mediators are not created equal. Some mediators are fantastic at big, giant, multi-party, complex, construction defect stuff. And I am so grateful that you are here, so I don't have to do this. Thank you, thank you, thank you. Others are fantastic at the bodily injury, fatality cases coming out of South Texas or out of Beaumont. The issues in those are so entirely different. The same thing happens in these insurance cases. Having a mediator with a deep understanding of both the liability and how that plaintiff's verdict happened, so they can speak the language they need to speak with the plaintiff's counsel. Because look, the plaintiff's counsel's there. He's got control of those plaintiffs. And he just won for them some commas. He or she is the only person the plaintiffs are listening to. That's it. He has them. They are in the palm. So we've got to be able to talk with him, and we've got to have a mediator who can talk with him. But I've got over here on the other side of the hallway, I've got insurance professionals who are doing math, running percentages, looking at reserves, looking at handling, and they are just coming at it in such a different manner with such a different set of priorities. And having a mediator who can talk with both of those groups, super challenging to find. We need more of them. So if you're on this call and you can do that and you haven't done one with Chris and I, we would love to have that conversation. There's my pitch, Jeff, to your audience.
Oh, you'll be getting a lot of emails, Jamie, I promise you.
We would love to have them. We're always looking for folks to help with these, and not just in Texas. I mean, that's something about our practice that we sort of get pulled to where the clients pull us to. I think Chris has tried more bad faith cases in North Dakota than any other defense counsel. And what a crazy state to have, defense counsel verdicts in. Right now we have some giant deadlines this week in some other states. And it's not work that we advertise. If you go look at our website, you're not going to see that because we really are a Texas firm, and we really are a Texas-based firm. But, every now and then the client calls and the client says, hey, we need your help. And so we're off to somewhere. It happens. I defended hospitals, aircraft manufacturers, insurers, and big damage cases. Yeah. You can see some really big cases out there across the spectrum, across all industries. It really just depends on, what comes out of the claim. So there are lots of opportunities, and really, this is one, they ask me all the time, Texas changes a lot, tort reform happens, this happens, that happens. And they're like, okay, have they killed this litigation in Texas? My answer to that is consistently no. Because plaintiffs' lawyers are so creative. They are so able to color outside the lines and find new crayons. And I do not mean that in a derogatory way. They are so stinking creative in a way that I am not. And so I really have great faith in claimants counsel, plaintiffs counsel, to always be looking at these things with a new eye and a new way to think about how they're going to help their clients. And they keep us on our toes. I feel like I'm always reacting. I'm never the one out there making the law. I'm never the one out there coming up with something new and interesting. I appreciate the work they do. All right, biggest mistakes we see in these cases. We're gonna pull back the curtain a little bit for the next few slides and talk about some things we see. I talked a little bit earlier, right? Plaintiffs' counsel overconfidence. They've just killed it at trial. They've run the table, if you will, on every issue, right? Like there was not a blank that the jury skipped, and they put 2 commas in every single one of them. They can be really, really overconfident coming in and make it super hard to negotiate. And you know what? That's okay. They've earned that right. They did a great job. But I think that's where everybody's got to be realistic, where everyone is and what the perspectives coming into mediation are, and where mediators can help. And sometimes you can't, right? I get it. Some plaintiffs' counsel, they're not going to hear it, and that's okay. I gotcha. I understand. They want a billboard that says they want $1 billion. I understand. It's going to happen. We're all going to run up against it. Mediation is an opportunity, right? All we can do is create the opportunity. Even the very best plaintiffs lawyers, though, are experts in the coverage and in the bad faith law. There are some out there. There's some out there who are really, really, really good. But they're very few and very far between. And I will tell you, those are not the folks that we have trouble getting stuff done with. Those are the ones we look forward to working with. Those are the ones we look forward to having on the other side of the aisle, if you will, because we know we can have a lot of fun. We know they're going to bring their A game, and we know they're going to challenge us. But at the end of the day, we're also going to get it done. They're a lot of fun to deal with and a lot of fun to work with. I feel the same way when they bring coverage counsel with them. I'm like, yes, somebody who speaks my language. We're going to get stuff done today. Appellate law. A lot of times they don't have remember, we're post-verdict. If it's our client, we're probably on an appeal. We've probably had some input into who their appellate counsel is. Maybe plaintiff's counsel either hasn't gotten appellate counsel involved yet, or maybe they're thinking they're going to do it themselves. We see that every now and then. That can be really, really hard, especially if we feel like we have good appellate points and we're going to come back and try this thing again. It happens. That can derail us pretty quickly. Always thinks their demand letters are perfect. In most jurisdictions, the elements that we talked about, they're pretty technical. They're pretty legal. They're driven by a statute, Florida. They're driven by some very specific case law, Texas. And there are very clearly defined elements. It is super, super hard to get one of those right. And there are very small things that derail them. When the burden is on the claimant to present the demand that complies, right? Not talking about those situations where the carrier has the burden to go out, right? Different situations. Frequently misunderstands the policy limits. We see this number one on wasting limits liability policies, especially in the malpractice arena, right? Or we've got a D&O and our defense counsel spend is part of that wasting limit. And they want $1 and the dollar is not there because we tried the case. And the towers of coverage, right? And how and what they have to do to trigger those towers of coverage. You know, when I'm the plaintiff's lawyer and I, you know, we can become best friends because the plaintiff's lawyer needs my help as primary coverage counsel to help him get to the rest of the tower. You get some real funny alignments among carriers, among parties, among counsel, depending on how the insurance is going to play out and depending on whose burden it is to do what. Really good mediators understand that, and really good mediators know how to pull people out of the room and say, hey, I need you to come up here and have a conversation with this person because y'all need to be friends, and help facilitate those conversations, because the mediator is sometimes the first person who has an eye to, oh, there's some more money here in the tower. Oh, this part of the tower came prepared. Oh, this other part didn't. Mediators can be hugely insightful into where we need to do more work.
Can you give an example or two of how this is actually played out in practice?
One jumps to mind, and we were in Beaumont. Surprise, surprise, Beaumont was one of the jurisdictions, and we had an individual. This was back when they required tank batteries to have a lid, a cover. Our oil and gas people on here can help me. They had to be put on them. This was legislation that changed at a federal level in the early 2000s. And so we had all of these workmen all over these oil and gas facilities across Texas putting lids, covers on tank batteries. We had an instance where an individual fell through one of those. Yeah, because they weren't finished yet. There was an open sort of manhole area and fell and did not die. So tank batteries are huge, right? They're 3 or 4 story structures. So injured horribly. We had all kinds of coverage there, all kinds of folks, all kinds of defendants are in Beaumont. Everybody's going to play. Everybody who can possibly be involved is going to be involved. And our mediator did a great job of figuring out who was there, he talked to kind of all the carriers individually, got a pulse on where everybody was. As I recall, I was up in the tower a little bit with my carrier, but I wasn't very far. I was pretty low. And so he was talking to me a lot faster than I thought he would have been talking to me. But it became very evident in those conversations that the 1 or 2 layers under me were prepared to tender. So I've got to go back to my client and say, hey, the 5-10 million, I don't remember what it was exactly. They are preparing to tender. They're going to be into your money in a heartbeat, and we need to know what our position is. And as he's aligning these various layers in the tower, he's also going back to plaintiffs who had coverage counsel there, very, very good coverage counsel. Where was he out of? I want to say he was out of the Carolinas, Atlanta, Georgia, somewhere in there on the East Coast. Fantastic, worked with him super well all day. And the mediator was these all in person. The mediator's facilitating these conversations as each sort of layer in the tower revealed where they were and revealed where their analysis was. And it went, I don't want to say it went quickly because it did not. This is back in the day, no Zoom, full mediation. Everybody's there. People have flown in from New York or Chicago or wherever they've flown in from. So there's a ton of money. There's a ton of money in the room. But my recollection is we worked really hard in the mediator's assistance in facilitating those individual conversations, and then bringing it back into the room once the mediator sort of knew where all the layers of the towers were. So, okay, here's where we're at. We need to have a conversation in the carrier room about the kind of money that's here, and sort of checked off what we had done very privately up until that point, of course, with our consent to tell the rest of the room, because we were going to need some help to get the rest of the money there that this plaintiff wanted. But really just masterful job in that situation. And really great job of also helping work with the plaintiff's counsel in understanding how much work we had to do in the tower in the room. Jeff, did I cover it? I answered with a story.
Oh, no, you did, Jamie. How about the situation where somebody relatively low in a tower or kind of in the middle, but clearly nowhere near the top, just balks, won't play ball.
Yeah.
And everybody else in the room knows that eventually that carrier is going to be toast, but they're holding up a settlement because the layers above them won't tender until the layer below them tenders.
Yeah, absolutely see it. We can see it where they draw a hard line. I'm kind of a hypothetical girl, so let's give it a hypothetical. Let's say we got a hypothetical where we're at 60 million in the tower, and this, everything below us has tendered, and we're sitting here at our 60 million, and we refuse to tender because we feel like they've gotten more than enough money to cover their damages. And we're post verdict, but we feel like we have good appellate points. We feel like we have good coverage points. Happens all the time. And we've got somebody sitting above us at 70 or 75 or 80 million or however the policy plays out, right? And 80 million, what I would expect, what I would do is I would send them what we call a hammer letter. Because if you're the carrier now that is making the call to stop the choo-choo train of getting this thing settled, that layer in the tower is now subject in most jurisdictions to claims from above them, right? The case in Texas, I think, is Roker. And it's really just an extension of the policy limits doctrine. Once you begin to trigger those layers in the tower, that duty to settle just moves right up the tower. That excess carrier doesn't get to sit back anymore when they know the layers below them have tendered. And we'll do it we will do it in both situations where we're underlying, let's say let's keep our math easy. Let's say that's $100 million demand. We're hung up at 60 million, and the 80 to 100 million is ready to tender, right? But they technically can't because we're missing the 20 million that would get us to the 100 million. So as the carriers below the 60 million, I'm going to tender to the $60 million layer, or I'm going to recommend to my carrier tender. Put this on them. They want this, put this on them, give them your money. And that way it's clear we're out, we have spent our money, take our money. We've explored, mediators appreciate this. We've explored, there's no way for me to carve off a piece of this. Let's say I'm that first, maybe $10 million layer. There's nothing there that I can get for my $10 million. I can't carve out a mom or a wife or a husband. There's nothing there that I can do to get my 10 million out clean. All right, so can I tender up? Always something we have to think about if we're trying to pressure a layer that's not going to participate, right? And then the layers above, if my layers above really think it's a $100 million claim, my layers above can hammer and they can say, if your failure to help us get this settled to the $60 million layer, causes us to now deal with this crazy excess verdict, you're going to be responsible for making us whole and repaying us because we have an opportunity to settle this today. So that layer, that recalcitrant layers, they're getting it from all sides, right? They're going to get it from everybody under them. They're going to get it from everybody above them. They're getting an earful from the plaintiff counsel, and they're getting an earful from mediator. And this is what I say: you can have some really unique alliances form that you don't expect during mediation because it's such a moving target depending on who's playing and who's not and how much money did they bring. So I don't know. Those days can be really, really fun if you've got a good cast of characters and everybody knows what they're doing. Those can be great fun days. They can also be really, really, really trying. We're counsel of record right now in one where we are the carrier in the file that is at the layer and we're done paying. We're going to try that case. That's Chris and my partner, Brad Allen. They're going to be in the Northern District of Texas in Dallas, we think on a spring 2025 setting. And it's trying as a pure coverage as a first party claim, not a liability claim. So it's not trying out of the third party context, it's trying in the first party context. But we're that carrier in that particular case. And with good reasonable basis to believe that. I think it's going to be a fun trial. I think they're going to do a great job with it. Okay. Kind of coming back to our list of things we've seen him. Sometimes the plaintiff's counsel just fails to understand why the carrier didn't take it, why the carrier's rejection of the demand was reasonable. Remember, we view this of the lens of what did the carrier know when the carrier rejected it. So if we've got a claimant's counsel that sat on medical records, or we've got a claimant's counsel that didn't give us everything they had, say we had video, or say we have some other piece of evidence that's going to be a clear dinger on liability, and they don't give it to the carrier. The carrier didn't have it in their field of vision when they made that call to reject the demand. The plaintiff's counsel knew it, right? The plaintiff's counsel knew what was in their bag of tricks, but they're not giving it to the carrier. So it's viewed with the lens of what the carrier knew at the time they made the decision. I would say for most plaintiffs or claimants counsel, that's as much art as science, right? And I appreciate how they don't want to reveal their whole hand. I get you. You don't want to show them everything you have. I understand. But you've got to show them enough to give them a reason to accept it and give them a reason to evaluate it at the policy limits that you're after. And if they don't, and then it comes out later that, oh, you didn't give them the video, because that's how we're going to try that case. We're going to, oh, you didn't give them the video and you didn't give them this and you didn't give them that. Of course, this carrier would have made a different decision, but this wasn't about that. This was about the plaintiff's counsel trying to get the biggest verdict he could get and stick the carrier with it. That's kind of sort of how that case tries. And that's not a bad case to try, because we look awful reasonable when the plaintiff doesn't give us everything. now flipping it a little bit, when the carrier has defense counsel handle the policy limit demand issues. In Texas, in California, that there are some laws, some policies, some things that say don't do that, right? Let your defense counsel go be defense counsel. Let them handle your insured, let them handle the defense. If you've got coverage counsel, separate the file, separate the claim handling, let coverage counsel, which your policy limit demand is probably coverage, unless you're going to accept it. If you're going to accept it, no, your defense counsel can do everything. But if we're going to fight about it, you probably need some help, and you probably need some help early. Can be a lot for defense counsel, as well as the competing legal and ethical obligations, right? As an attorney, when I'm hired as defense counsel for the insured, that's who I owe my duty of obligation and loyalty to. And I want every darn penny I can get to settle the case, right? I'm not worried about the carrier. I'm not worried about the coverage. How much money can I have? The plaintiff wants X. I need X. It's like an entirely different conversation when I'm hired by the carrier and we're evaluating what the coverage is and how is the carrier evaluating the liability. Two completely different hats that counsel wear. A lot of times, and I'm sure the mediators that y'all have done this enough, y'all have seen it, right? That hat switching is hard to do, and not always well done. Lack of documentation. Our claim file for the carrier has got to be able to tell the story of what we did. It has got to have the detail of how we evaluated it. It has got to have the detail of what we were looking for. It's got to have the detail of what we had. If it doesn't have what we need to tell our story, it's awful hard to do that. And if we're in depositions 4 and 5 years after this was rejected, my claim handler is not there anymore. My claim manager is probably not there anymore. I'm going to be super lucky if my claims VP or chief claims officer is still there. Sometimes they're still the same carrier, but they're in a different role. And I might not get them for their deposition because they're in a different role. So it's got to be in the claim file because somebody else is probably picking this up and having it and having to deal with it. And we won't have it sometimes. Depends. It totally depends on the carriers. Some carriers do a fantastic job. Others do not. Or don't do as great a job, I should say. I'll be generous. Handling the appellate bond, which I mentioned. That appellate bond on these excess verdicts, when they exceed the policy limits, they are sticklers, and how you deal with them changes on a case-by-case basis. Again, I think for the mediators, I think it helps y'all to know who has skin in the game, because if the carrier's already bonded the judgment, they're already in. They're not getting that bond back if they lose the appeal, right? So they're already in. If they're not, if the plaintiffs cut a deal because they're not worried about that measly $1 million, that tells you how invested the plaintiff's carrier is in it, right? It tells us huge things on how that appellate bond was dealt with. Plaintiff's counsel also it'll exceed limits. Defense counsel assumes we're going to be below limits. People come into these, in my experience, with really unreasonable expectations both ways. I think the limits it's an interesting data point. I don't think the limits is controlling for either party. I think so many other things are in play on these, and depending on the tower. All right, hiring the wrong mediator. I said it earlier, and I'll say it again. These are tough to do. If you're a mediator and you're not doing them and you're interested in doing them, I think Chris and I would be happy to have that conversation as well, and would be happy to point you to some folks that would maybe have a conversation with you that mediate these on a regular basis. Because I'll say it again, we need more people who can do them. And I think I think the talent issue that we see here is no different than the talent issue we're seeing with attorneys or with trial lawyers, or even, with the carriers, right? We just have some talent things going on across the board. So, I have about 10 minutes left. Jeff, you want to take some questions or talk about anything? I feel like I just went 300 words a minute really, really, really fast. So.
Well, this was fantastic, Jamie. You certainly covered a lot of territory there. Let's talk more. We have a lot of mediators on the line. Let's talk more about what makes for a good or bad mediator in these circumstances? You talked about certain mistakes that other players make. What are some common mistakes that a mediator might make in this kind of situation? And what can we do to prevent those mistakes?
So let's talk about it from things that I see you've done really, really well. So that way we can be positive about it. Number one thing I see done really, really, really well is that on these, the mediator will ask me for the mediation report maybe 2-3 weeks out. And then and normally I'm coverage counsel or I'm counsel post excess verdict for the carrier. Then after they get my report, about a week later, they'll ask me for a phone call. And I will actually have a call, an hour or so, just to go over the carrier's position and just to go over what we sent to them. And it's normally not even to talk about numbers, whether I have 1 million or 10 million. It's just to talk about how are we evaluating the case? What are we doing? What are we looking at the coverage? How strongly do we feel about these appellate points we've told him about? He's usually read it. He or she has usually read it. They've usually looked at my cases. They've usually looked at my policy language. We might have a deep dive on the policy language if they think I'm wrong. And then he'll say, okay, thanks for the conversation. I'm going to go talk to the other side's person who does what you do. And then we may have a follow-up conversation. And we haven't even gotten into the mediation yet. But they've already gotten into the issues and they've already gotten into what are the parties' position, and we haven't even showed up yet. Stephen just posted that worst mediation experience has been where the mediator does not understand the case, has not read or understood both sides' memoranda. Absolutely. And I guess that's what I'm saying. I'm trying to frame that in a really positive way, where those mediators are doing the extra work ahead of time to really be sure they understand the case, because they know they've got the liability, right? And they know they've got a plaintiff counsel who's going to be there, who's just won this monster verdict, and that's what they're going to hear about, right? And how much they thought that how great a job the jury did, and how much the jury thought all this pain and suffering or whatever it is was worth. Okay, then you've got the layer of the excess verdict lawyers who are there, who are going to talk about, no, when the carrier rejected the demand, we were reasonable. And here are, the 10 reasons why we were reasonable. And then you've got this other layer of the coverage lawyers, very possible, that are just going to talk about, here are the impediments to the policy language that keep this from being a covered claim and why our behavior was reasonable. And then you've got your appellate counsel, right? We're just going to talk about the appellate points. So we've got just these layers of sophistication on these mediations. And are they that crazily different from other mediations where, if I'm old enough that like when I came on board, like Ford Firestone was still a thing, right? And we were still doing all of that litigation. And so that big complex products liability, multiple, plaintiffs, multiple defendants, multiple competing insurance policies. Is it really that different? No, it's not really that different. It's just a lot of moving parts and people with a lot of different roles. So understanding it ahead of time, understanding those roles ahead of time, and understanding when I come as coverage counsel, I don't care what the jury did. I really do not. They can put as many zeros or as many commas in the blank as they want to, because it doesn't impact how I'm going to read the insurance policy. And I'm just not interested in hearing it. Sure, you can tell me it's a data point. Okay. But it's not going to impact the analysis that I have to do. So, and I think really, really, really good mediators get that, and they understand how to frame their communication in a way that fits that person's role and how they're involved in this thing. So, and I think that would come back to any mediator, right? Really, really good communication. Great mediators are great communicators. They understand the party's objectives. They understand their positions. And I think that the other thing I'll add is they understand where the opportunity is, right? Okay, we're going to get an opportunity today, but man, we're all going to have to work really hard to get there because nobody's going to be happy about it, right? I love hearing that, because that told me, okay, there's a possibility. Okay, we got to do some work. I didn't come to work not expecting to work. I'm happy to work. Just let me know. And also the mediators that are like, probably not going to happen today. Okay, tell me that too. I'm not going anywhere. I'm still going to work. We're still going to do what we can. But that really helps me understand where the other side, or maybe not the other side, where somebody else is that's going to be our holdup. Because it's not always the plaintiff's counsel, right? Like we talked about in the tower analysis. It can be somebody else in the tower that's going to prevent us from getting there. And then we have to look for where are the alignments and where can we bring pressure and maybe change the dynamic or influence the dynamic that the mediator read. So that's where I would say, and that's all so soft skills, right? It's all about soft skills, right, Jeff?
It's one of the great days in my mediation career, Jamie, was when I realized, yes, I do use all my lawyering skills, and I have to be amateur psychologist a lot of the time too, in order to get the job done, and there's nothing wrong with that.
Yeah.
So let me ask you, on these large cases, 8-figure cases, do you find that the trial lawyers are, generally speaking, sophisticated, unsophisticated on coverage issues? When that much money is at stake, do they not go and get one of the name brand policyholder side coverage firms to advise them when that much is at stake?
Yeah, on the big cases is where we see them go get counsel. They'll show up with really great guys who also, women as well, who have their names on the books and who speak on a regular basis. And the thing about coverage is we're such a small group, really within the bar. We all know each other. So there is nothing that makes me happier when some policyholder counsel shows up on the other side that I already know. Because we're gonna have a conversation. Normally, in those pre-phone calls, the mediator is gonna call me up and say, "Hey, do you know so and so?" And I'm like, "Oh yeah, I know so and so. He's gonna be coverage counsel for the plaintiffs." Okay, outstanding. And I think your point is right. The more likely the plaintiff's attorney is to have, his own private plane or his billion-dollar billboards, he's a really great plaintiff's attorney, and he knows he's a really great plaintiff's attorney, and he knows enough to let someone else go deal with these issues for him or her, right? And that's what we see. Very seldom do I see one of those kind of guys or women want to do their own coverage. I just, not at that level. I don't see it.
Yeah.
It's the lesser cases. And they're not lesser, but I would say like from 10 million down is where sometimes you don't have all the players that you would want to have.
Got it.
It's not
Jean
small, but
Jean Lawler, you lived in this world for many years as managing partner of a significant law firm representing insurance companies. We have a couple of minutes left if you have any questions.
Well, Jamie, I just loved hearing the vocabulary. I can totally understand and relate. So well done. Thank you. I really didn't form any questions. I loved what you had to say. It all made perfect sense to me. Been there, done that. And kudos. Thank you so much for being here.
You're very welcome.
Yeah, there's another question here in the chat that's interesting, I think. Bob Tessier, who I used to work with at one point. Do you find joint sessions effective in these types of cases?
It depends. It depends on what they want to accomplish with a joint session. If they want to replay the monster verdict that they just got, and it's going to make them feel good, okay, it's not really going to influence anything going on because we already all know. Sometimes if it's just to say hi, to make sure everybody knows everybody and put names and faces together, okay. Very seldom am I, as coverage counsel, going to have something to say. My real concern with joint sessions at this point is that I don't want to trigger anybody. I don't want anybody to leave the room because I explained that my carrier had a reasonable basis to reject your demand, right? The last thing I want to do is start the day off with somebody mad at me. That's not conducive to being productive. So it depends. still doing a few joint sessions. Most joint sessions I've seen at this point are just sort of welcomes and introductions and making sure that everybody knows who everybody is. But something more than that, I think is dangerous.
I agree.
Um,
Yeah, there you go.
we had
Oh,
a question earlier about mediators from out of state serving as mediators in Texas, and acting as a mediator would be considered unauthorized practice of law. I have not run into that issue, and we mediate with out-of-state mediators. I have never had, interesting, I've never had someone complain about it, and normally you're going on an agreed basis anyway. I mean, I know somebody up here earlier had mentioned they were out of Arizona. Like, I know on some of our big CD cases, I know we're mediating with Arizona mediators on that stuff. And I know that on some of the other big stuff, we're mediating with some folks out of state. So, you know, I don't have a real good answer for you, other than to say, I don't think so. But, you know, I think it's a really wise point, because we have seen some really strange things going on with the bars and unauthorized practice of law, and being much more aggressive. In mass claims case with multiple defendants, some with more financial resources than their combined aggregate insurance limits, are there effective ways to resolve possible insurance subrogation claims? Absolutely. Chuck is asking about, you know, the subrogation and how that comes in. We're out of time. Chuck, another layer. We did not have time to get into subro and how the various claims between the various carriers and against the various defendants could come into play. Whole another topic that, you know, really, really good subro lawyers take on, that we could do another whole hour on, I think. So,
And maybe we'll have that chance soon, Jamie. We are out of time. On behalf of Jean and Natalie, who's not here today, I want to thank you. We want to continue to wish Chris Martin all the best. We miss him today. We hope that people, if they're in a position to contribute, support the Houston Food Bank. It's houstonfoodbank.org in your honor and in Chris Martin's honor. Thank you so much for an excellent, in-depth, and stimulating presentation. And with that, we are complete.